I'm going to ask my colleagues, members of the committee, to please come to their seats, and we are going to start on time. I will first ask the clerk to open the roll.
Todd, can you quote me real quick? Yes. Thanks.
You have a quorum, Madam Chair.
Thank you so much. We do have a new member who has joined us, Senator Rouse. Senator, would you mind introducing yourself and telling us what jurisdiction you represent? Thank you.
Good morning. I am Senator Aaron Rouse, representing Virginia Beach, piece of Norfolk for Senate District 7. Good morning. Glad to see everyone here this morning. Thank you, Madam Chair.
Thank you so much. As usual, we have a few housekeeping items, so I'm going to go through them. I would like a motion to re-refer Senate Bill 1245 to Judiciary. May I have a motion? Second. Okay, would the clerk please open the roll? There are
Ayes 13, no 0.
Thank you. We also have a motion. I will need a motion. The patron's request, Senate Bill 1371. Senator Vogel has asked that that bill be stricken.
So moved. Second.
The clerk, please open the roll.
Ayes 14, no 0.
Okay. Senate Bill 1128, Senator Morrissey's bill. The patron had asked that that bill be stricken. May I have a motion?
Second.
Thank you. Would the clerk please open the roll?
Madam, what was that number again?
1128.
Thank you.
Ayes 13, no 0.
Thank you. Senator Peake at Senate Bill 966 just asked that that bill go by for the day. All those in favor signify by saying aye. Aye. Okay, it's unanimous. The bill goes by for the day. Okay, we're going to start with our docket. I will ask that committee members go last. The chair will go absolutely last. So let's start with who might be in the audience. Do I have any patrons in the audience who are not committee members? I do not. Okay. Let's start with Senator Boysko. Are you ready?
Yes, ma'am.
Okay, Senator Boysko.
Good morning, Madam Chair and colleagues. Today I have SB 1274, which would make free for families telephone calls to people who are incarcerated. This bill is a cost-effective investment with a positive public safety impact for families and communities. We know that when we know that 90% of the individuals who are incarcerated are going to come home, we want to make sure that they are ready and have community connections. Maintaining ties with family and community is itself part of that reentry program, and studies show that it's one of the most effective ones we know of. More contact with incarcerated loved ones is found to reduce harm of the force of separation, and the benefits of communication are especially clear for families with children, parents who are incarcerated and their kids. So one of the things that we talked about last year, I brought a bill before you that would have made communications free, as well as a whole host of others. It was a rather large bill. This year, we did a study with the DOC, with stakeholders throughout the year, and many of the stakeholders, there was not a recommendation through the DOC, but many of the stakeholders believe that if there were one thing that we could achieve, it would be to have the ability for communications without cost to the loved ones. And so that is what my bill is. Now, I do want to say that I've had some conversations with DOC this morning, and I would like us to be able to take testimony, but I'm also it may be that we want to work the bill a little bit more, but I do have some folks who have come from out of town to testify, if that would be okay.
Okay, let me just clarify. Do you have an amendment you want to offer at this time, or would you rather just take testimony?
So the amendment that I would have would be that the Commonwealth take the responsibility for paying for the DOC's communications for the phone calls. We, in the initial bill, it has several other stipulations. The one concern that we're still working on is making sure that when we do this, it's not just going to be one 5-minute call a day or one 5-minute call a week, that we want to make sure that there's some sort of a floor, but we don't have that language worked out immediately.
Let me ask General Counsel. Mr. May, is it appropriate, if you will, if we sort of accepted this amendment in concept, because this does have to go to finance.
Right.
So I would rather move it along, but let me know your thoughts on this amendment.
Madam Chair, we could adopt an amendment in concept. I would probably need a little bit more information as far as, it sounds like one of the items is still up in the air. If we could get a determination on that, we could adopt something.
Would you, Madam Chair, perhaps we should hear the testimony from the folks who are here and from DOC, and then the committee could
Okay,
decide.
I will also ask DOC for technical assistance on
Yes.
what exactly this amendment would look like.
Absolutely.
So we have clarity if we're going to vote
Thank
and
you.
move it on.
Thank you.
Okay, Senator Boysko, you have some speakers.
Yes,
Those
ma'am.
in the audience who wish to speak in favor of Senate Bill 1274, please come forward.
Good morning, everyone. Thank you so much for having me. My name is Bianca Tylik. I'm the Executive Director at Worth Rises. We're a national criminal justice organization that works to pass exactly bills like this that help reduce the economic impact of incarceration on incarcerated people and their families, and also promote public safety. I want to talk a little bit about this bill today, and
Excuse me,
also,
Bianca, slow down just a little bit.
I know I don't have that much time, and I'm from New York. I talk
Yeah.
fast. I'll slow down.
I'm asking speakers if they could speak for about 2 minutes, but go ahead.
Okay,
Your
I will
clock
do
will
my
start
best.
now.
I
And I
understand
know-
every word.
What'd you say?
I understand every word. 'cause I
Oh,
talk
thank
fast
you.
too.
Thank you so much.
Colleagues, just, again, just have conversations go through the chair so we have some
I
order.
apologize.
Bianca, go ahead.
Thank you so much. So I just want to say, in this 2-minute sort of period, really quickly, that providing communications is the most cost-effective program that you can provide in prison. That doesn't mean it's free, for sure. But what it does mean is that people are able to connect with their families and build the necessary supports that they need in order to come home. So this isn't just about supporting incarcerated people or families of whom 1 in 3 with an incarcerated loved one goes into debt over the simple cost of calls. 87% of those carrying that burden are women, and disproportionately Black and brown women. What does that mean? That means that this is not just a criminal justice issue, it's an economic justice issue, a gender justice issue, and a racial justice issue. But it brings people home in a way that is meant to be safer for our communities. They are more likely to have housing, more likely to have employment, more likely to have social supports that makes them less likely to return to prison, less likely to victimize others in that process, and less likely to depend on government support. This bill, we have actually enacted in other states, and I want to name that. There are several states that have now implemented this bill, and there are roughly a dozen states considering that bill today and in this legislative session. Importantly, we are willing to work with the DOC, and if the amendment is allowed, we could even workshop that this morning before the committee's over. I want to also mention that this is a coalition that is across the sort of political lines. It is a strong coalition. In every state that has passed this, it has been a bipartisan bill, and here in Virginia, we expect it to be the very same. It's not just the left, it's the right, the left, all coming together behind this bill because we believe what it will do for public safety. Personally, as a victim of crime, my partner, I will just say, was murdered. I stand up here as somebody who knows that this is what keeps our community safe, people who are connected to their families, and not as someone who's simply just a bleeding heart for those inside. Thank you.
Thank you so much.
Good morning, Madam Chair.
Good morning.
Members, Richard Walker, founder, CEO, Bridging the Gap in Virginia, formerly incarcerated convicted felon. When I was incarcerated in rural Halifax County, Camp 23, we didn't have that opportunity to make phone calls to our family members. We didn't have that opportunity to make a smooth transition from incarceration to back into society. You know, this legislation will allow for that. It will allow for fathers to have a constant contact with their children, that when their release or their time is up from prison, that will add for a smoother transition for them to welcome back into the home, back into their community. So on behalf of Bridging the Gap in Virginia, we support this bill and hope that you will too. Thank you.
Thank you. Mr. Winetta.
Thank you, Madam Chair, members of the committee. Sean Winetta speaking on behalf of the ACLU of Virginia. We appreciate the patron bringing it forward, and I know we need to work on the language a little bit, but we appreciate bringing it forward and support the bill. Thank you.
Okay.
Good morning. I'm Abby Phillips with the Legal Aid Justice Center, and we support this bill.
Thank you.
Ben Knotts, Americans for Prosperity. We support the bill.
Morning, Brad Hayward with Justice Forward Virginia. We also support this bill.
Good morning. Does anybody in the audience oppose this bill? If so, please come forward. Oh,
Madam Chair,
sure.
one
Yes.
more.
One more.
Salim Kalfani from the Virginia Interfaith Center for Public Policy, and we support the bill.
Very good. Thank you. Okay, audience, we're now on speakers who are in opposition to the bill, and then I will move to Zoom.
Thank you. Good morning. My name is Maggie Cleary. I'm the Deputy Secretary of Public Safety and Homeland Security. We oppose this bill. This bill would cost DOC and taxpayers of Virginia almost $11 million. Currently, inmates are allowed to make phone calls to their friends and family. The cost to them or to their friends and family is approximately 40 cents a minute. We believe that this is reasonable, and we ask that you oppose this bill. Thank you.
Thank you.
Good morning, Madam Chair, members of the committee. My name is Jerry Fitz with the Department of Corrections. We oppose this bill, but we oppose it in its form that it's in now. One of the challenges that we have with the bill is that there's some limitations that will be put on individuals in terms of video visitation. We wouldn't be able to limit some folks from video visitation. We want to have that ability to do so because we have sometimes individuals act out, and we want the ability to be able to monitor individuals who actually allow to have home video visitation, things of that nature. Also, I would just say, I know it's been talked about before in terms of the work group that we had. I think we had a very good discussion throughout the summer. I think that we tried to come to some common ground. I think we did do that. I think one of the issues that we have is that we don't disagree that communications with families is a very important part of reentry. As most of you all know, Virginia has a recidivism rate that's either has been number one or number two in the country for a number of years. So we understand the need for individuals to be able to connect with their families. Our concern, as it was last year when this bill was proposed, is just the funding of it, whether it be through families paying for phone calls, for visits, for messaging, or if it is for a taxpayer-funded model. Whatever that is, we don't want to lose that ability to be able to have individuals connect with their families.
I will ask the patron, did you submit a budget amendment, Senator Boysko?
Actually, Senator Peterson has submitted a budget amendment.
So there is a budget amendment.
There
and
is.
the conversation on financing will take place in the
Yes.
Finance Committee. Okay, I'm now going to move to Zoom. We've got some speakers. For those who are in favor of the bill on the virtual platform, please indicate so.
Juanita Belton, you may provide your testimony. Good morning. My name is Juanita Belton from Sisters in Prison Reform, but I'm actually speaking on as a family member. The young lady said, 40 cents a minute seems reasonable. It does seem reasonable when you're not the one that's paying for it. I had my loved one who was incarcerated for 24 years, and over the last 2 years before he was released, I paid at least $300 a month or more on emails, on telephone, on video visits just to stay connected. It's not just about reentry, which Mr. Fitz mentioned. It's also about the time that they're spending in totality incarcerated. They need their loved ones, and it shouldn't be on the burden of family members to cover all these costs in addition to the outside costs that they have to pay for just to live. It shouldn't be this hard to help families stay connected to their loved ones, because once they get out, they're going to need that connection. So I wholeheartedly support this bill.
Thank you. I'll remind the speakers and the clerk to please note 2 minutes. Thank you for your testimony. Would you please call the next person in favor?
Sheba Williams, you may provide your testimony.
Yes, good morning. Thank you all for having me. My name is Sheba Williams. I am the executive director of No Left Turns, and I was on the work group this summer. We spend close to $2,000 a month for communications to ensure that we can plan with individuals who are close to release. Our services are reentry and pretrial support. It is also paramount to note that in the past decade, there has been an 800% increase in the number of women who are incarcerated. 87% are mothers and or heads of household before their incarceration. Our organization has a less than 2% recidivism rate, and communication is paramount for family reunification and ensuring basic needs are met when people are returning to our communities. So it is important that this bill be passed. We support it wholeheartedly. Thank you for your time.
Thank you.
Santia Nance, you may provide your testimony.
Good morning. My name is Santia Nance, and I'm a Sisters in Prison Reform co-founder, but definitely the loved one of someone who's incarcerated. I've heard everyone's testimony, and the one thing that I actually wanted to say that I feel like hasn't been mentioned yet is really just talking about the hope that communication brings to people who are incarcerated. My loved one specifically, we've been reconnected for 3 years, but the thing that's been the most impactful is seeing how much that communication has helped the people around him, the people in the pod, the people who don't have family members who I can send a Christmas card to and make an impact on their lives, and they start to feel like they have someone out there on the outside. It would be absolutely amazing if we could find a way to make sure that other family members can stay in touch with their loved ones without having to go into debt. Thank you.
Thank you so much. Is this
We have
one more
we have
speaker?
Several more speakers, Madam Chair.
Okay, please close the entree to the platform. Go ahead, call the
Sammy
next
Perez,
speaker.
you may provide your testimony.
Good morning. I'm actually here to speak on Senate Bill 846. So I'll pass on this bill.
Okay.
Charles Meyer, you may provide your testimony.
Good morning. Thank you for having me. I'm here as a policy fellow for Julian Legal, urging you to support this bill. One thing that I would like to emphasize is the fact that this bill not only helps the people who are currently incarcerated, but it also has strong positive impacts for their family members. This is an intergenerational opportunity that we're creating to create long-lasting positive impacts, not just for incarcerated people, but for entire communities. A very small investment can create enormous impact that will strengthen our communities, lower recidivism, and keep Virginia one of the safest and most responsible states in the Commonwealth. Thank you.
Thank you. Clerk, please call the next speaker.
We have one more speaker, Madam Chair.
Thank you.
He's being let in right now. Willie Brown, you may provide your testimony. Mr. Brown, you may provide your testimony. I believe he's having difficulties, Madam Chair. Should we?
We're going to proceed with the hearing then. Senator Boysko.
Thank you, Madam Chair. May I recommend that we pass this by temporarily, allow me to have another conversation with the DOC to see if we can find the language that would be most effective, or would you be comfortable moving this forward and we continue to have negotiations?
I would like to hear from DOC.
Okay.
I'd like a sense of what that amendment is.
Yes, ma'am.
And it's possibly we could move that along.
Great, thank you.
Madam Chair, the question that I was asked this morning from some of the folks who were in favor of this bill was the limit on calls for inmates per day. Right now, there is no set limit on calls for inmates per day. However, wardens, based upon operations of the facility, can limit inmates to 5 phone calls a day. And I think that was some of the concern around the amendment that was going to be proposed for this bill. So I believe that may be more sort of question for the patron or one of the witnesses.
Senator Boysko, your bill says the maximum number of telephone numbers permitted on an approved cell list. So that's the maximum number shouldn't be more than 20, but a minimum ratio of 1 telephone per every 10 inmates shall be available. Is that a problem?
And Madam Chair, we're willing to strike that portion of the
Okay,
bill.
would you make that amendment, please?
I move that amendment.
Okay, is there a second? Colleagues, did you hear the amendment? Second. Okay. All those in favor of accepting the amendment signify by saying aye. Aye. Okay. So that line is now gone, and the only content here now is talking about the number of approved call numbers. Anything else that you?
Madam Chair, under lines 29 and 30, there is under little I, two I's, shall not exclude inmate from using the system and shall not receive communication, any commission. I would suggest that because DOC needs the ability to make limitations if there is a behavior issue, I recommend that we take the little I, the double I, shall not exclude an inmate from using the system, to remove that.
Okay, motion has been made. Is there a second?
Second.
Okay with that?
All those in favor signify by voting for this amendment or signify by saying aye.
Aye.
Aye. Okay. Do you have a question, Senator DeSteph? I'd like the patron to finish her amendment process and then.
I've got a question dealing with clarification on one of the statements that Madam Chair you had said regarding the maximum number of telephone calls at 20, but the way this is written, it says the maximum number of permitted on an approved call list shall be no fewer than 20.
That is correct.
I want to make sure I understand this the right way. You had said one thing, I read it a different way.
You've read it correctly.
Okay, so there will be at least 20 approved numbers on each and every call list.
Madam Chair, I believe we struck that language.
Yeah, I believe we have.
Struck that.
Mhm.
Yes.
Okay.
Okay, so that sentence had been struck, and we did strike the small double I down on line 29. That's where we are, colleagues. Any further amendments before this goes forward to finance? Yes, David, go ahead.
Madam Chair, just to clarify, are we also striking in the first section the minimum ratio of telephones per inmates, or are we retaining that sentence?
You're okay with that?
Would your question?
We would like for that to remain the same.
He would, Madam Chair, we would like it to remain consistent to what the policy is now.
So what change would that be?
I think we just strike that language,
Strike the languages, I guess.
holding the current ratio to whatever it is.
Okay. We're going to have David read all the amendments.
And Madam Chair, we would keep the piece that says the department shall not receive commissions from the telephone systems on line 20 and 21. That would remain in the language.
Okay.
So we're really.
Senator Boysko, does that conclude your line amendments
Yes,
for the
ma'am.
moment? Okay. Colleagues?
Madam
Colleagues,
Chairman.
listen up. I'm going to have David May read the amendments that we've made to the bill. And I believe we voted on each amendment.
We have.
Okay, David, go ahead and read each amendment.
Madam Chair, looks like there would be 3 total line amendments. The first would be on line 18, after call period, strike the remainder of line 18, all of line 19, and through correctional facility on line 20. And then the second amendment would be on line 29, After visitation, strike the comma, insert and. And the third amendment would also be on line 29. After Romanet 2, strike the remainder of line 29 through Romanet 3 on line 30.
Okay. I think that's puts the bill in better shape. Senator Cosgrove.
Thank you. Senator, two questions for you. You said Senator Peterson had put in a budget amendment. Do you know how much that budget amendment requested?
Yes, sir, I do. It is, he combined a couple of different policy initiatives around DOC. The total of it is 13 million, but it's also including removing commissary commissions as well. So it's a combination. Okay. My understanding is the fiscal impact is more like $5 million.
All right. So the other question is...
Senator Cosgrove.
Thank you, Madam Chairman.
And I could be incorrect. DOC might have that answer, Mr.
Thanks.
Again, that'll
Mr.
be a topic for finance. Mm-hmm. Senator Cosgrove.
Thank you. Is this just Department of Corrections, but will this impact
Correct.
jails?
Nope. No, that was Madam Chair.
That's a separate bill.
Mr. Cosgrove, that was
Senator
a
Morris's
different bill.
Yeah.
This is only Department of Corrections.
Okay, colleagues, the bill is before us as amended, and it must be re-referred to finance. May I have a motion?
So move, Madam Chair, refer to finance.
Okay, may I have a second?
Second.
Okay, will the clerk please open the roll? Your bill reports, but it's re-referred to finance.
Thank you, Madam Chair.
Thank you, Senator Boyce.
Ayes 9, noes 5.
Okay, well, we now have a few patrons. All right. Senator Stewart.
Good morning, Madam Chair.
Good morning.
Members of the committee. I've got Senate Bill 1022, and Madam Chair, what Senate 1022 Bill 1022 is an information bill. So we've had a lot of discussions over the last few years about criminal justice reform. And from my perspective, there have been a lot of questionable facts inserted into that, probably from both sides, Madam Chair. And facts are critical when making decisions in criminal justice reform. And so that's what I've done with this bill, is try to strike a fair balance to get that information out so that we have the appropriate facts so that we can actually make good decisions in this field, which I think all of us want to do. And really, that's the bill. It requires the Department of Corrections to provide the Virginia State Crime Commission with information regarding those that are released early, which some of us want to know. Others might want to know why they're not released, and we get that information. It includes conditional release, discretionary parole, geriatric release. Again, both sides of the aisle want to know that information, maybe for different reasons, but they both want to know that information. And so that's the bill, Madam Chair. I tried to strike a very fair balance in this, but I think it's important if we're going to be effective. It's a very difficult area. I guess I've been practicing in this field either as a defense attorney or a prosecutor. Prosecutor for a much shorter time, but probably 25 years as a defense attorney. And if you don't have the facts, you don't have a chance in making good decisions. So that's my bill.
Okay, I actually have a technical question. The Crime Commission has advised me that they already received some data, but the extent that you're requesting in your bill would be a lot of additional data, perhaps a new website to be created. There would be significant workload issues. Is that correct? Would you agree with that?
I just spoke with Kristen, and she had some questions regarding whether or not I was looking for it retroactively, and I don't believe I am, but prospectively. But I think we'll see how the committee feels about the bill, and then I can work with the Crime Commission to narrow this. And we don't want to do anything that's extraordinarily expensive, obviously. But we all need this information.
I have a further question. Is the representative from DOC here? I'm just trying to clarify what information is already being provided. Welcome. We're on Bill 1022, and...
Yes, ma'am.
Okay.
And good morning again, Madam Chair. Jerry
Good
Fitz with
morning,
the Department
Jerry.
of Corrections. We don't have a position on this bill. In terms of reporting out, we actually have this information for us. We already published some of this information in some of our current reports. And if you look on our website, we've got some of this reporting information. I don't want to speak for the parole board, but I do know that they also, there's some information that's published on their website as well in terms of releases and things of that nature.
So there is a fair amount of information already publicly available.
Yes, ma'am, it is. And also, we, if we had to do this, it would require the department to perhaps put the way that we report the information into a different posture. But certainly, we would have the ability to be responsive.
Thank you.
Madam Chair.
Senator Morrissey.
Madam Chair, when you had that colloquy with the witness, you respectfully spoke over each other. The witness said that they published some of that information. You responded by saying, so all of this information is already out there. And I think the purpose of Senator Stewart's bill is to make sure there is one location where you can get all of this information. So I'll ask you specifically, does the DOC right now provide all of the information, including reason for early release, the remaining time on the schedule, on the sentence, for each offender, the length of sentence originally imposed? Is that already, all of that information as set forth in the bill, sent by DOC to anybody?
Madam Chair, Mr. Senator, no, we do not. No, we do not publish all of that information right now. We do have access to that information, though.
Follow-up question for the
Senator
Senator,
Morrissey.
Madam
Senator
Chair.
Morrissey.
Thank you. Senator, do you have, not that this is dispositive, a cost for this?
I do not. Madam Chair, I don't have a cost yet.
This is going to be referred to finance.
Madam Chairman.
Right. At the appropriate time, I want to speak very briefly to the bill, Madam
Okay,
Chair.
I will have to take speakers at some point. Let me ask, is it Senator Servo? Senator Servo.
I had a question for DOC.
Okay, representative, come back.
Yes, sir.
Thanks. So, I'm on your website right now. There's a press release that says Virginia's recidivism rate remains among the lowest in the country. It's a DOC press release. So, it appears to me that DOC calculates recidivism rates every year. So it seems to me like you're already monitoring people's reoffense rates in general. And so, is that accurate? I mean, you guys do that every year? Do you constantly monitor recidivism rates and to see how your programs are working?
Madam Chair, Mr. Senator, yes, that is correct. We are currently, we do monitor our recidivism rate and the recidivism of those who are released from our custody. As you probably know, it's one of the more important things, one of our driving forces at the agency, our programs and how that relates to our recidivism rate.
Okay.
Okay. I guess there are no further questions from my colleagues. For those in the audience who wish to speak in favor of this bill, please come forward. And I'm going to ask that you limit your remarks to 1 minute. This is a very straightforward bill. You can speak less than 1 minute if you so wish.
Again, my name is Richard Walker, founder, CEO of Bridging the Gap in Virginia, reentry program. I've, over the past years, for the purposes of identifying individuals that might need to get their rights restored, I've reached out to the Department of Corrections to see if they had any data on where these individuals are located, just to give me general information that we can target that area, that population. I've reached out to the parole and probation office. They have no information on where and how to locate individuals, So this is imperative in order to, because there's still hundreds of thousands of individuals that have yet to get their rights restored after being released from incarceration. So that is of essence at this point, that some database be created to identify the localities that have those massive amounts of individuals that were released from incarceration. That way they can get support from organizations such as myself, as well as be able to reach out to them to help them to get their rights restored.
Okay, thank you. Your time is expired. Anybody else in the audience wishing to speak in favor? Okay, anybody on Zoom wishing to speak in favor?
Anyone on Zoom who would like to speak on the bill, you may raise your hand.
In favor?
We have none, Madam Chair.
Thank you. Anybody in the audience wishing to speak in opposition? And there's nobody on Zoom, is that correct?
Anyone on Zoom who would like to speak in opposition to the bill, you may raise your hand. We have none, Madam Chair.
Thank you. Okay, colleagues.
Speaking briefly, Mr. Chair.
Conversations with the commission.
Madam Chair, speaking briefly to the bill.
Senator Morsi.
Madam Chair, I look at this bill as one of transparency. I understand what it might be used for, but the bill requires that there be a central database for the reasons for early release. I'm going to publish the names of the offenders, their original sentence, and the reasons for release, whether it was geriatric or not. And Senator, I'm going to support this bill, but I have no doubt that part of the genesis of this bill was that for some people to be able to have quick access and be able to say, look at, Willie Horton here, who was charged and sentenced to this, but he got out early. It will be used for that purpose. But because it provides more transparency, which I've always pushed for that singular reason, I'm going to support the bill.
And thank you, Madam Chair. Senator Morsi, you're exactly right, but then you also get the data to refute that position. And that's, as I say, we tried to strike a fair balance here, because the only way we make good decisions is if we have all the facts. And we can all live by the facts, but we listen to these debates, and oftentimes the facts are misinterpreted, misconstrued. This gives us the real facts.
All right, colleagues, I will
Madam
just
Chair.
note that this will have to be re-referred to finance, but we need to take a vote. Yes, Senator Servo.
Thank you, Madam Chairman. First of all, I serve on the Crime Commission, and I don't remember us ever passing a bill directing the Crime Commission to do anything. Usually if that happens, it's a bill that came from the Crime Commission. It's already been vetted and reviewed and looked at by the Crime Commission. The Crime Commission's ascertained that it has the staff and the capacity, the ability to do it, and the Crime Commission wants to do it.
This isn't a study, though.
Well, this is directing the Crime Commission to do things. And every year we sit down in the executive committee, we talk about how much time we have to do certain things. We budget out that time for the year. We figure it out, make a plan this year on a bipartisan basis, and that's how we decide what to do. So this is kind of very abnormal, first of all, in that respect. Secondly, if what we care about is recidivism and preventing recidivism, we already get all that information. And what's important is the overall trend, not what happened in one individual person's case that often people use and take up and they wave around to say, this person got released early, and they never should have been released early. They went back and did something bad. Some policy was bad. And what I think putting out that type of individual information creates more sort of distractions and diversions than it does what we glean from the overall trend, which in Virginia historically has been very good. And so this individual data, I think, has the capacity to mislead and create confusion more than it does help. So anyways, Madam Chairman, I think this bill, if it does go out of here, needs to go to finance, but I think the normal practice would be to PBI with a letter to the Crime Commission. That's the Crime Commission. The Crime Commission wants to do this or look at it as opposed to us telling them what to do.
I was going to suggest that might be the better approach. Motion has been made. Is there a second?
Motion to PBI?
PBI with a letter to the Crime Commission to evaluate this. Second. Okay. Okay, go ahead.
Second.
Okay, let's vote on the substitute bill, a substitute motion, rather.
Ayes 8, noes 6.
Thank you, Madam Chair, members of the committee.
So the substitute motion, it is reported out and re-referred to finance.
Thank you.
Mr. David, do I have to do another motion on PBI? I don't think I do, but I don't think I do. Okay, all right. I always like to hear from General Counsel when I have a question. I know I have a lot of smart people on my committee. Okay, let's move on. Who else is? Senator Obenshain, would you like to join us? You have 3 bills, as I see.
Madam Chair, members of the committee, I think you notified my office that one had been or was going to be re-referred to courts, 12:45, maybe?
Yeah, let me just confirm that for you. Yeah.
And I caught you briefly yesterday evening to ask if 12:42 could possibly go by for the day, which would leave me, if you consent, with one.
12:47 would leave.
12:47.
Okay, I'll ask the committee. May I have a
So-
motion?
so moved, Madam Chair.
Okay, all right, so 12:42 is going by for the day. All those in favor signify by saying aye.
Aye.
Okay.
Thank you.
Hear any opposition? That goes by for the day. Go ahead.
So, Madam Chairman, members of the committee, 1247 is a parole bill. It's a reform and transparency bill. It's fairly modest in scope compared to some of the bills that have dealt with parole over the past couple of years. And really, this has 5 different things that it does. I hope that you'll like all 5, but I believe that if there is 1 or 2 that you don't like, you could eliminate those and move forward with the ones that you do like. So the 5 things that it does: number 1, this requires that decisions by the parole board to grant or deny parole have to take place in person, following an in-person meeting and a discussion. And I think that this is a common sense measure that enhances the likelihood that there is going to be a meaningful discussion and a substantive determination based on the merits of the decision as to whether or not to parole somebody. I think, it's easier to grant or deny parole if you've got a virtual meeting, a telephone meeting, or a Zoom meeting. So that's number 1. Number 2 is during past couple of years, one issue that came up was the ability of the chair of the parole board to unilaterally release inmates from post-incarceration supervision. And this would end the unilateral authority of the chair of the parole board to do that and require a meeting of the parole board to make that determination. Number 3, very often there is no current interview of the applicant for parole, and this would require that there be a current interview that has been conducted by a member of the board or by a designated member of the staff. And I mean, if I'm up for parole, I certainly want to have my opportunity to be heard and to be able to make my case and to address a staff member or board member, and not to simply have my determination made as to my potential release without a current interview package. Fourth, current code provides that the parole board has to endeavor diligently, quote, endeavor diligently to contact victims. That has been a big problem. There have been too many instances in which paroles have been addressed, granted, or denied without endeavoring diligently to contact the victims. This removes the words endeavor diligently and requires contacting the victim in order to move forward. And then 5th, to facilitate victims' rights, it would allow victims to provide virtual input into parole decisions. Right now, it is required that they provide input orally, and the parole boards have interpreted that fairly strictly. and have not allowed virtual comments and participation. So this makes it clear that victims can participate virtually in this process. So those are the 5 things that this does.
Okay, thank you, Senator. Do you know if there are speakers in the audience to support the bill?
I know there are people who support the bill, but I don't know whether they're
in the
people here.
audience. Okay, I am now going to ask speakers who support this bill to come forward.
Madam Chairman, I have a quick question for the
To
patron.
please limit your comments to 1 minute.
I had a really
Before I
quick-
take speakers, I will ask Senator Surabel.
Thanks, Senator. I had I saw an article online about 2 weeks ago about a 28-page report from the Parole Board Chair, Chad Dodson. It looks to me like this bill pretty much parallels what that report says. So is this basically an administration bill?
This is a bill that it did not come to me from the governor's office.
Further question, Madam Chair.
Senator Surabel.
Is it based on this report that the Parole Board Chair wrote? Because it looks to me like it parallels a lot of his recommendations.
I did have communications with the chair of the parole board, but this is, I mean, it's not an administration bill that I know of.
It could be
Okay.
based on the report.
Well, is there an administration bill based on that report?
I don't know.
Okay, thanks.
I don't know. It did not come to me from the governor's office or the administration. So I've worked with, I've communicated with the chair, I've worked with the Attorney General's office on it, but I don't think it'll come as any surprise that I've been involved in parole issue for several years, for better or worse.
Yes, I understand. Okay, sir, you're speaking in favor of the bill. Could you please limit your comments to 1 minute?
Thank you, Madam Chair, members of the committee. I'm Chad Dotson. I'm the chairman of the Parole Board. I'm here to speak in support of this bill. Essentially, it does codify current practices of the board, but practices that have not been always followed. So I don't have much to say other than we do support the bill.
I have a question.
Certainly, ma'am.
How often does an interview take place that is not in person? Maybe done.
An interview with a parole-eligible inmate.
A parole-eligible inmate.
All of our current interviews they're not in person, they're all virtual at this point, but we do speak with each parole-eligible inmate annually.
I mean, this bill removes that option completely.
Removes the option to do it virtually.
Yes, it has to be done in person, as I read it.
Prior to 2020, they were done in person.
They don't do it in person.
Thank you.
And we could do that.
Mr. Chair, Madam Chair, questions?
Senator Morrissey and Senator Boysko, did you have a question? Okay.
Thank you. Thank you, Madam Chair. Good morning, Judge Dotson.
Good morning, Senator.
First of all, I want to commend you on your efforts to run the Virginia Parole Board under what have been very trying circumstances, including not having all available members, what you've done with COVID, and I think you probably brought a certain amount of expertise from your role as a judge from 2011 to 2020. With that said, a couple of questions. You gave a report or an interview on January 9th of this year calling for, above the board or beyond the box transparency. Have you been able to initiate some of those transparency measures already in your capacity as chairman? That's my first question.
Certainly, yes. We are reporting on our site. We report things we're not required by law to report, reporting decisions on parole violators that we make. And we're trying to work within this system, Chorus is the name of the system, the DOC system, to effectuate more changes so we can publish basically everything we do.
All right. You and I spoke in your office, and I was impressed with some of the steps Madam Chair, some of the steps you've taken. In this bill, though, it calls for a live interview of the prisoner. I thought that when we discussed it, there were efficacy measures for not interviewing the prisoner in person, but either over the telephone or sending some other alternative measure. Was I wrong?
It's certainly easier for us because the parole examiners that conduct these interviews, I have a set of 10 parole examiners, and they're all part-time wage employees right now. So it's certainly easier for us to be able to have them at the office or at their locations at the various probation parole offices and to conduct them virtually.
Follow-up question. So you don't support having an in-person interview with the inmate on every occasion?
The administration takes no position on that, Senator.
Okay. Follow-up question.
Last question, I think David may be able to clear up.
I'll defer.
David, why don't you go ahead?
Madam Chair, if you look at line 86 of the bill, it clarifies that the live interview of the inmates may be conducted in person or by video conference or telephone at the discretion of the board.
Last question, Madam Chair.
Senator Morrissey.
The bill talks about the victim being able to opine or weigh in on parole, but isn't that currently the protocol of the Virginia Parole Board? You want and you encourage and you make every effort to get that victim, but sometimes you can't because you can't locate the victim, right?
Senator, yes. The fact is we have a lot of cases dating back to 1969 even where locating victims is difficult, but we try to use every means at our disposal.
So, and this is the final question. If the bill required that the victim or victim's family member be interviewed in person prior to be granting parole, and you couldn't find...
It doesn't require that. It requires contacting the victim.
Okay.
It doesn't require any interview.
I'll rephrase it. If the bill requires to contact the victim or family member before giving parole, but you cannot find the victim, does that mean that that inmate could not avail himself of parole?
You want to speak to that? Senator?
If you don't like that, strike that section.
I don't like it.
Strike it.
Yeah, would you please identify the lines you're making a motion to strike?
Yeah. David has it, Madam Chair.
Okay.
Madam Chair, on line 109, we would unstrike endeavor diligently to.
Okay, colleagues, that's an amendment.
I have no objection to that.
You consider it a friendly amendment? Okay, all those in
It's
favor of
relatively
adopting
friendly.
that amendment signify by saying aye. Aye. Thank you.
Are you going to indulge me for one final question?
One final question, Senator Morrissey.
Senator Dotson, Judge Dotson, Chairman Dotson. The bill provides that final discharges may be issued by the board upon approval of a majority of the members, okay? Is it a majority of the members or all of the members?
A majority of the members,
Right.
I believe, is.
That's what I
My
thought.
bill says majority of the
Right.
members.
Currently, for some offenses, I think capital murder, maybe another charge below that, I thought it required more than a majority.
See, that portion of the bill is dealing with release from post-release supervision, not release from incarceration.
All right, thank you. Thank you for that clarification.
Okay,
Sure.
Thank you. Senator Boysko?
Thank you, Madam Chair. In the third portion of the bill, around lines 23 to 26, says no decision to grant discretionary parole shall be made by the board unless the decision was discussed and debated at a meeting at which all members were present. Why all members? Why not a quorum? What if the board is not filled with that?
Well, if the board is not filled, all members are the existing members. So if there's a vacancy on the board, all members are, it's like the members of our body.
Sure.
We've operated for a week or two with 39 members.
Yes, sir.
That's all.
Thank you, Madam Chair. Just to follow up, so
Senator Boysko.
why don't we say a quorum instead
those appointed.
all members? A quorum of those appointed, as we do in the General Assembly or any other of our boards and commissions and bodies.
I I don't think I would strongly object to that, but, think about it, I mean, from both sides. I mean, what if, you had somebody who is, opposed to granting anybody parole, and they are the ones, that's the person who's there, and the soft-hearted one can't be there. I mean, I think that, that there are good reasons for all members of the board to be there, irrespective of, the perspective with respect to incarceration and release. I think, that's important. It's not a hill I would die on, but, I think that there are two perspectives on that.
Thank you.
Did you want to respond?
Madam Chair, might I
Yes, you may.
just say, I actually strongly support that provision. We only have 5 members. 3 of them are part-time, and yet we have no trouble we have weekly meetings. They're all there. And frankly, I think having the entire board making decisions as really monumental as releasing someone from supervision, I think requiring the entire appointed board to vote on that, I think is probably a best practice.
And one last.
Senator Borsco.
Thank you. And this is for you, sir.
Sure.
How many releases have you all granted this year, or post-supervision releases? Have you granted?
Post-release?
Well, both this year.
I don't know the numbers, and I will get those to you, certainly, but the number of post-release supervision discharges are very few, very few. Those requests come from, to be released early from supervision. Those requests come to us from the local probation and parole offices, and we take it in front of the board. And the board, we've not granted an early discharge in months, but I'll get you the precise numbers by the end of the day.
Thank you so much. Appreciate your service.
Thank you, sir.
Okay, so we're now on speakers who might be in favor of this bill. Please limit your remarks to less than 1 minute.
Yes, Madam Chair. Again, Richard Walker, founder, Bridging the Gap in Virginia. I've secured the release of probably about 30 individuals, providing housing, transitional housing from them that have been released before and after and during COVID. I attend meetings on a regular, parole board meetings on a regular boat to advocate for the families of their loved ones. At one point, they were interviewing the individual prior to or thereafter the families have met with the parole board. I don't know if that's still a practice now, where they'd have an investigator that would go into the prison, the facility, and they would meet with that individual. That way the family is aware that he's coming up for parole, and they can go in on behalf to meet with the parole board. I just was in the parole board meeting last week, and that's where the family got the information that their son is coming up for parole. So I'm hoping, believing that that continues, but more importantly, they need to expand the parole board. 5 individuals is not enough to determine someone's fate, whether to be remain incarceration or to be released back into society. Thank you.
Okay, thank you for your remarks. Mr. Winetta?
Thank you, Madam Chair, and members of the committee. We would like to support. We're sort of on the fence on this, and there's a couple things that Senator Morrissey, of course, pointed out, and Senator Boysko as well, and some language concerns, and particularly around all board members present again. Now, let's say there is only one member, as we sort of ran into last year, there was only one member of the parole board for a period of time. Well, what if somebody goes out on, one person or 4 people go out on maternity leave for 3 months? That leaves us 3 months without a board and no decisions being made. So that's certainly one concern. And another one down in the publishing of the records, and I don't know if this is something that council could address, or perhaps Senator Servell, Madam Chair, if this conflicts, I would say lines 55, the publishing 55 through 61, if that interacts with or conflicts with our expungement and record sealing laws that we just passed in recent sessions. So
Yeah, I'll ask David
So,
May if he has a.
thank you for allowing me to testify.
David, do you have a reaction to the comment that lines 55 maybe through 60 may affect our expungement language or sealing of the records?
Madam Chair, immediately offhand, I do not. I can look into that further if you want.
Madam Chair, I think that simply conforms that portion with the disclosure requirements for releases from prison on parole. So, I think that we crossed that river a couple of years ago with Delegate Scott's bill, and this simply provides for the same disclosures with respect to release from post-incarceration supervision. I may be wrong, but I think that's the case.
Madam Chair,
Senator Servell.
I think the prior witness's point, though, is that we passed a record sealing law that would allow Class 5 and 6 felonies to be sealed after a period of good behavior, and that this report or whatever might conflict with that, although the person would have to be out for a period of time before that. And
Can we say unless prohibited by code section, whatever, that
Would that be acceptable?
sealing provision? I don't intend, it wasn't my intention to be in conflict, put this in conflict with that.
Of course, we can always remove your, your requirement in here about the annual report. Would you
Prerogative of
consider,
the committee, certainly.
would you consider that a friendly amendment?
Not really very friendly, but
I think we're uncomfortable with the way it currently reads. So I will ask Senator Servell what your preference is on.
well, I'm not a fan of the bill, so.
Okay.
But,
All right.
I mean, that's kind of where I am. I mean.
So be it. Let me, just for purposes of tying up a loose end, David, what recommended language would you offer if we wanted to ensure it did not conflict with our sealing of the records?
if you want to make really sure, I think the chair's suggestion, probably the best one, just take it out.
Just take it out. Okay. It is a motion. Okay. All right, David, do you want to clarify what I think I want to do for everybody?
Madam Chair, it sounds like if we're going to take out that particular piece, that would entail striking the language on lines 57 through 61.
Yes, that is. Okay, that's the motion.
Right.
To strike lines 57 through 61. All those in favor of that amendment signify by saying aye. Aye. Okay, that amendment's adopted. Boy, we're really working hard. I believe I have heard from people in favor of the bill. Anybody in opposition in the audience? Okay, seeing none, is there anybody in our virtual platform that wishes to speak to this bill, either pro or con? Please limit your remarks to less than 1 minute.
Anyone on Zoom who would like to speak on the bill, you may raise your hand. We have no speakers, Madam Chair.
Thank you. Okay, colleagues, the bill is before us. David, do you want to just go
There's
over
no
our amendments?
fiscal.
Yeah, but I just want to make sure everybody's clear what we're voting on.
Madam Chair, yeah, there would be two line amendments. The first would be at the beginning of line 57, strike all of lines 57, 58, 59, 60, and 61. And the second line amendment would be on line 109, at the beginning of the line, unstrike endeavor diligently to.
Right.
Right.
Okay. All right, that's the bill as amended. It does not have to go to finance. I'd like a motion. Motion has been made to report as amended. Is there a second? Would the clerk please open the roll?
Ayes 5, noes 9.
Thank you for your hospitality.
Thank you, Senator Obenshain. Don't take these votes personally. We did care to have the discussion, though, so thank you for that. Okay, next on our docket, I think I have to move to, I don't see Senator Marsden, and I don't see Senator Suderline. I did see Senator Suderline. Is Senator Suderline here? Okay. He may have moved. Senator Mason, in the meanwhile, I'm going to call you to do your bill. It's very quick. Should be.
Madam Chair, Senate Bill 1219. Well, you want to go? You go. I live here, man. Okay, I didn't know you lived here.
Okay. I see you're a gentleman. Okay.
He is very
Sure.
kind.
Yes, Senator.
And I will
Suderline.
be very concise in my remarks. I have a straightforward bill for you, Senate Bill 1015, Madam Chair. And what the bill seeks to do is codify the current and best practices, as have been usually the case at our parole board, by requiring that when the mandatory investigation is being conducted to determine if someone should be released or not released pursuant to parole from the Commonwealth's custody, that while that investigation is taking place, that the Commonwealth attorney in the jurisdiction where the charge they were convicted of is notified so that they can share their thoughts on it. And that's what almost always happens, and that is what I believe should happen.
Madam Chair.
Senator Morrissey.
And if that doesn't take place, or the Commonwealth's attorney, the current Commonwealth attorney, does not weigh in, what are the consequences? If your bill passes and the CA is not contacted or doesn't weigh in, what are the consequences on the individual seeking parole?
Well, I guess at the beginning of the code section, or at the beginning of the paragraph, it just specifies that this is what is to happen.
Follow-up question.
Yes, sir.
Senator Morrissey.
Yes, Madam Chair.
And feel free to defer to Judge Dotson behind you.
Yes, I was going to say, he's about to speak if you'd like to.
Here's my question. A Commonwealth attorneys come and go, depending on the will of the electorate. And an individual who's up for parole may have already served 3 decades. There may have been 3 or 4 or 5 Commonwealth attorneys since then. What is the benefit of contacting the current Commonwealth's attorney versus the parole board reviewing the pre-sentence report that took place 20 years ago and the facts and circumstances of the case that occurred 20 years ago?
Well, first, I would say, having grown up in Fairfax County, the idea that you have 3 or 4 CAs.
Okay, 1 or 2. Don't focus on that.
I mean, CAs are one of the most constant offices in most of Virginia.
Madam Chair,
Senator
that's not my
Morrison.
point. 30 years later, when the parole board is considering granting parole and the prosecutor that was there at the time isn't there, what is more beneficial? Contacting the current Commonwealth's attorney or having Judge Dotson and his folk review the pre-sentence report that was done at the time?
Well, I think that there's value in doing both those things, but I will let the man who actually has to review that answer that question.
Thank you, Senator Suderline.
Judge Johnson.
Thank you,
Come
Madam
forward.
Chair.
Thank you.
I think the answer to that is sometimes it's not going to be valuable getting the input of current Commonwealth attorneys. But ultimately, these decisions all have to be rooted in, there's a number of things, wide variety of things we have to consider. One of those obviously is public safety. And the administration strongly supports this bill because we feel like it asking the chief law enforcement officer in each jurisdiction about a public safety question should be part of the entire picture. I will say, I'm sorry.
I misspoke. I jumped in. Finish your thought.
I will say that when this is a current practice of the board, and often the value in it comes when a Commonwealth attorney looks at the case and says, you know what, we either agree with or don't object to parole.
Final question, Madam Chair.
Senator Morrissey.
Judge Dotson, I was very impressed when we talked about your experience as a circuit court judge, general district court judge, and what you tried to do in the parole board. But can you imagine ever a situation where the parole board called up the new Commonwealth attorney or the new chief of police, or the chief of police and said, what do you think about paroling this person who was convicted of murder 30 years ago, and having that person says, go for it. Would you ever imagine a situation where the constitutional officer or the chief of police would give you the okay?
Yes, and we see it regularly.
All right, thank you very much.
Madam Chairman.
Senator Servo.
And I don't care which one he answers this, I guess, but, I mean, Section 155, subsection B already says, electronic notification shall be sent to the attorney for the Commonwealth. So, I mean, the law already requires a notice, and if the Commonwealth attorney wants to weigh in, they don't have to. Why are we making the Commonwealth attorney, why are we adding all this extra color to something that's already in the code?
I think what's already in the code, Senator, is that we have to notify the Commonwealth attorney after a decision to grant parole has been made. Just alert them within 21 days, I believe, of the actual release from prison.
No. Madam Chair, it's subsection B says, an investigation pursuant to section shall include notification the victim may submit to the parole board evidence concerning impact. The notification shall be sent to the address. If additional victim research is, this is about victim research.
Yeah.
We are required to
Okay.
contact the victim, certainly, or endeavor diligently,
Okay.
but no one else.
Okay, I got it.
Thank you for that clarification. It was certainly a pending point of conversation. Senator Suderline.
Well, if there's no any other questions, just to wrap up, I think there is value in the doing both, just like our chairman of the parole board said, getting that information. I also think, I don't think the CA offices move around as much as has been suggested. And I think there's significant value in the current CA, even if it has changed over, being notified, because often the folks that had this charge, it was of a serious nature. And there may have been other folks involved in the CA might be able to provide some helpful information about what the situation they might be going back into is, so that they can make the most informed decision.
I do have a question, but go ahead, Senator Boysko.
Thank you, Madam Chair. So one question is, the crime occurred in, let's say, Goochland, and the incarceration is happening at, let's say, Caroline County. The person who is planning to leave, like if they are going to be leaving the DOC and have, applying for being released, they might be planning to move to their home and community might be in a completely different part of the Commonwealth or outside of the Commonwealth. They might be from New York. What value do you think it brings for the person who is currently sitting in the location where the crime occurred, when the person might not even have any connection to that community and might not have any plans to return to that community? I'm a little confused. I understand what you're trying to get at, but I don't know that I see.
Madam Chair, I would suggest that this person has significant connection to that area. That's the area where they at least were when this crime was committed. Most of the time, that's the area where they lived. As you see in it's a pretty short bill. The reason that we're asking the CA for their input is may submit input to the board regarding the impact for the Commonwealth and on the local jurisdiction. And it says it will remain in the file. And so that also, I think, one, if it's not an issue, they can move on. But if it is significant that someone committed this crime in Fairfax or Manassas or wherever it was, the CA can say, hey, here's why this is noticeable. This is what the impact will be. And if, say, at that time it's denied, it stays in the file going forward. And to Senator Morrissey's point, well, what's the difference 30 or 40 years from now? It stays in the file, and they can get to see, well, the CA at the time was concerned about release at this point because of these other factors, and they were afraid that they might be more likely to get involved into a problem of a serious nature again. And that was 10 years ago. And now we no longer think that's the case. But that's what the CA at the time said, and they can move on. I mean, I think you either think that the Commonwealth Attorney should get to know and the Commonwealth Attorney might be able to provide some benefit. I'm not claiming that the Commonwealth Attorney gets to make the decision. I'm just saying that I think we should include the Commonwealth Attorney.
But the input would remain in the prisoner's parole file.
Yes, ma'am.
That's what I have a problem with. Okay, are there speakers in favor of this bill in the audience? Seeing none, are there speakers in opposition? Oh, you're in favor.
I just want to say, Madam Chair.
You support the bill?
I'm Chairman of the Parole Board, Chad Dotson, and we do strongly support the bill.
Okay, thank you. And are you in opposition? Those coming forward, keep your remarks to less than a minute.
Yeah. Again, Richard Walker, Bridging the Gap in Virginia. You know, this is usurping the authority of the probation parole office. You know, if they're doing what their due diligence in regarding individuals to be released, why is it that they have to be reported to the Commonwealth's attorney for further investigation? You know, I just think that this bill is just like, it serves no purpose. Thank you.
Thank you.
Thanks for
I will ask the clerk, are there
First time
any
I met him.
speakers in the
Didn't
Zoom?
talk to me before. Love it.
Are there any, excuse me, we're not ready for a motion yet. Are there any speakers in the Zoom room?
Anyone on Zoom who would like to speak, you may raise your hand. We have none, Madam Chair.
Thank you. We are now ready for a motion.
Madam Chair,
Yes.
we respectfully move to pass the bill by indefinitely to PBI it.
Okay. Second. Okay, motion has been made and seconded. Okay. I will deal with the substitute motion first. Substitute motion is to report the bill. Clerk, please open the roll.
Ayes 6, noes 9.
In these cases, I usually ask for a motion. Again,
Madam Chair, move to PBI the bill.
Ayes 9, noes 6.
Thank you, Madam Chair.
Okay. I was going to go to Senator Mason and then Senator Morrissey.
Thank you, Madam Chair. Senate Bill 1219 has nothing to do with parole, thank goodness. But it does deal with this slightly weighty topic of barrier crimes. I think Mr. May has an amendment to the bill, if he could speak to that. Please, ma'am.
Madam Chair, we do have two line amendments. I'll go ahead and read them first. The first is on line 86. After conviction, insert a comma. The second is on line 86. After any, insert offense set forth in clause 4 of the definition of barrier crime in section 19.2-39202 that involved heroin, fentanyl, or meth. And basically what these do is I think the original language of the bill may have unintentionally taken out an exception to barrier crime that already exists in current law. So this amendment would simply clarify that the persons who already have an exemption after 10 years have passed from a possession of a controlled substance offense is retained under the language of the bill.
Thank you. May I have a motion to accept the amendment?
So moved. Second.
Okay, motion has been made and seconded. All those in favor signify by saying aye.
Aye. Thank you, Madam Chair. Thank you,
Bill's
Mr.
amended.
May. So you will recall that we've been working over the years to try to promote kinship adoptions, kinship foster care. And since we started talking about it, we've gone from the single digits, and I always get the number wrong because we're doing so much better, like 17, 18%, but still low. So we're doing all we can to promote that. Last year, I came to you and asked you to approve us using the federal requirements for barrier crimes allowing adoption. The gentleman from Hanover said, nope, bad idea. We passed it out of the Senate, and you know what? You're right, sir. There were some crimes in there that just ought not to be included. And so we went to a work group in the off season, and my goal was to have a red, green, and a yellow light. Red, you will never be a foster parent, all right? But Arson of a field is on that list. I'm thinking we might ought to be able to slip you in there. So there should be some greens on the list, with yellow being referred to a judge or a board or what have you. That was far too extensive, and I'm going to continue to work on that, but we couldn't quite get there this summer. So what we've done is we've polled the community service boards, the social services, local social services, and largely seen that drug possession is one of our biggest impediments. So what this bill asks to do is to take Schedule 1 and 2 possession charges and allow kinship foster care after 5 years, with the exception of fentanyl, heroin, or meth. If those were included, you're out, and until the 10-year mark, which is the amendment Mr. May just made. After 10 years, if you've done the regimen of requirements and passed the drug test, had drug counseling, there are like 4 or 5 things you have to do, then you can be a foster parent after 10 years. But in the short term, what we're doing is trying to allow it in keeping with, as I said before, the federal requirement of 5 years for possession, with the exception of those 3 drugs. After 5 years, you could indeed, and this is kinship foster care. That's the bill, Madam Chair.
Sounds like we're making progress.
We're trying.
Okay, thank you for your presentation. Are there any speakers in the audience in favor of this bill? If so, come forward and be very brief. Less than a minute, please.
Madam Chair, members of the committee, last time Senator Mason brought this bill, Senator McDougal raised some really important questions about, we thought we could just track the federal statute language, but that was very amorphous, and Senator Dougal noted that we didn't really know how the effects would go. So I think Senator Mason was right to bring people together to examine this, and my understanding is that he's also spoken with Delegate Bell, who also had concerns about it last year, and Delegate Bell did actually participate in the meetings around this, which I think was really good. The chair knows that children do best if they must be removed from their families when they're placed with relatives. And yes, Virginia has been down at the bottom for relative placements for a long time. We are creeping up, and this will help us get to the national average, which is 30%. So we support this bill. Thank you.
Thank you.
Oh, sorry, I didn't say who I was, but I think you know.
Okay, that's Ms. LaRue with the Virginia Poverty Law Center.
Hi, good morning. Rebecca Morgan, President of the League of Social Services Executives and Director of Middlesex Department of Social Services. And the League supports this bill and is certainly in support of increasing the number of relative placements for our children in foster care. Thank you.
Thank you. Is anybody in opposition to the bill? Seeing none.
Madam Chairman?
Oh, yes, Senator.
Can we get a tape of this for Reagan? Because when she tells me I'm wrong all the time, I want her to have somebody else saying I'm right.
Does it pain her as much as it does me, sir?
Yes, it does. It probably pains her more.
Now we have a better bill, and I'm sure you'll support it. Let me ask the clerk, do we have anybody in the virtual room?
Anyone on Zoom who would like to speak, you may raise your hand. We have none, Madam Chair.
Thank you. Okay, the discussions with the committee. Okay, motion has been made and seconded to report. Please open the rolls.
No, that's cool.
Ayes
I understand.
14, no 0, abstentions 1.
Thank you, Madam Chair and members
Well
of the
done.
committee. I really appreciate it.
Senator Morrissey, do you mind if I have Senator Marsden come, because he's a guest? Okay, Senator Marsden, you can come forward.
Thank you, Madam Chair. Senate Bill 994.
Okay. And this will have to go to finance, did you know?
Yes, ma'am.
Okay.
Very definitely.
All right. Colleagues, I draw your attention to Senate Bill 994. Go ahead.
Okay, thank you so much. Senate Bill 994 creates the Office of an Independent Ombudsman, create oversight for our prison system. The reason I'm bringing this bill is back during the McDonnell administration, we eliminated the Board of Corrections. The only oversight we had for our prison system to have oversight over the management of over 25,000 inmates and, which is what the number is today. And they changed that board into a board of local and regional jails, which is great. It still, conducts oversight there, but there's nothing for the Department of Corrections other than the line of command, which starts as a sergeant on a cell block, working up to the shift captain, to the warden, to the regional administrator, to the deputy director, to the, eventually ending up to the governor. And nobody is getting a picture of what's going on the ground level, because it filters its way, all the way up. And you know how bureaucracies work in that regard without this kind of oversight. When I ran the Department of Juvenile Justice, I had a board member who saved the day for this Commonwealth by insisting that we do something about the Beaumont Juvenile Correctional Center, which was out of control. The administration at that time was ignoring it. It wasn't getting done. And Chip Harding, lieutenant in the Charlottesville Police Department, went on to be captain of the colonel of state police in Albemarle County, stuck to his guns and got it done. And we were able to come in and fix things because people were in a situation to do that. So very quickly, as senators, we can't address problems that we do not know exist. The Department of Corrections is responsible for 25,000 Virginians and the staff members who work with them every day. We all want to improve the health and safety of these individuals. In an integrated environment like a jail, you have to care as much about the inmates as you do the staff. They're all in there the same together. They just have different roles. And somebody has to look at how they're treating each other, how the guards are treating the prisoners, how the management is treating the guards. It's just information that we don't have. That's why we need independent oversight so we can address issues faster. In addition to that benefit of helping Virginians, we can catch problems before they become big, expensive lawsuits and bring transparency to taxpayers. This is what the governor needs, because it's going to report to him so he has an independent view of what's going on. Okay. Exercising physical control of other human beings is the most dangerous, difficult thing we do in the Commonwealth, and we have no oversight over that. We don't know what's going on. You all get the letters. You all get the emails from inmates. Some of them are self-serving. Some of them are real. The words you get from the guards in the inmate system, the correctional officers, the problems that they have. Some of them are self-serving. Some of them are real. You need somebody to sort this out and create the transparency. And so what this bill does is deal with who's going to be on the board we appoint people, the House appoints people, governor appoints people. We have stakeholders who are involved in the process. It does have to go to finance. It does have a cost. And, very quickly, we could go through every detail of this very long bill, but you know the concept here, and that's how this works, and that's why it's needed.
Okay, I think we're primarily voting on the bill before us, but I'm sure there will be tweaks. I will ask the speakers to just come forward with a yay or nay, the effort in the interest of keeping the meeting moving forward. Those in the audience in support of this.
Sean Winetta on behalf of the ACLU of Virginia, and we support the bill. Thank you.
Thank you.
Ben Knotts, Americans for Prosperity. We support the bill.
Thank you.
Virginia Interfaith Center for Public Policy, and we support the bill.
Thank you.
Richard Walker, Bridging the Gap in Virginia, fiercely support the bill.
So noted.
Brad Haywood with Justice Forward Virginia, we support.
Okay, thank you. Is there anybody in opposition in the audience? Seeing none, I will ask the clerk, do we have anybody? Oh, of course. Welcome.
Thank you, Madam Chair. Jerry Fitz, Virginia Department of Corrections, and we oppose this bill.
Jerry, since you represent the Department of Corrections, I will just ask you to make a brief statement. Why do you oppose the bill?
Yes, Madam Chair. It is our belief that what the senator is trying to do with this bill, some of those guidelines or those guardrails are already in place. Certainly, there's some very specific information, but I would just share with you that the Department of Corrections reports to the Secretary of Public Safety, obviously. In terms of investigations, certainly the Inspector General's office has the ability to provoke investigations. We rely on the Department of Criminal Justice Services in terms of our guidelines for training. Certainly, the Department of Justice has created policy around how prisons are supposed to be ran, and we run our facilities within those guidelines as well. There's American Disabilities Act gives us direction on how we respond to inmates who have certain issues. And so, with that being said, I know I probably sound like a broken record, but with all that being said, two things I'll leave you with. The Department of Corrections is led by a leader who has been in a role of leadership of departments of corrections for many, many years. And I think that speaks to the recidivism rate that Virginia currently enjoys in terms of the policies and procedures and the reactiveness when things do arrive. So for those reasons, I would say the Department of Corrections is in opposition to this legislation.
I understand, and I'm not surprised.
Madam Chair,
briefly-
just one quick closing statement. We have a well-run Department of Corrections. The director is Harold Clark, has done a wonderful job. He's not always going to be there.
No,
You
understand.
don't know who's going to be there. This is about running a system, not judging a current administration. And there is no Board of Corrections anymore. We got to restore something.
I understand.
Madam Chair.
I just want to, one quick question. I just want to confirm with the clerk, we have no speakers in the virtual room.
We have several speakers, Madam
We
Chair.
do. Okay, let me take the question. Who had asked a question? Senator Morrison, let's take the
other
speakers.
folks go
I
first,
will
Madam
ask the speakers to either indicate they are in favor or they are not in favor.
Charles Amari, you may provide your testimony.
This is an aye, this is a yes or a no?
Chuck Meyer, truly and legal. We support the bill.
Sean McGowan, you may provide your testimony.
Sean McGowan of Virginia Police Benevolent Association. We do support this bill.
Allison Chaffin, you may provide your testimony.
Allison Chafin with Ignite Justice, and we support this bill.
Sheba Williams, you may provide your testimony.
Sheba Williams with No Left Turns, and we support the bill.
Francis Ross, you may provide your testimony.
Thank you. Francis Ross, Inmate Support Virginia. We support the bill, and if the DOC is already doing all those things, I'm not sure why they oppose it.
Okay, does that conclude our speakers?
We have no more speakers, Madam Chair.
Thank you. Okay, Senator Morrissey.
Madam Chair, fellow members, just as I supported Senator Stewart's bill because it provided greater oversight and transparency, I'm supporting this bill, and I'm going to give you 15 seconds examples. There were some problems. I'm not going to get into the details at Riverside Regional Jail, at Lawrenceville Correctional Facility, which is the only private facility, and it took a while for it to percolate to the top. I visited both of those facilities on more than one occasion and was able to glean what the problems were. What Senator Marsden's bill does is allows people that are close to the ground to get those problems and enunciate them and bring them forward in a transparent fashion soon. So for those reasons, I thank the senator for the bill.
Okay, Senator Morrissey, it's time for a motion, and this has to be re-referred to finance. Okay. Motion's made to report and re-refer. Please open, clerk, please open the roll.
Ayes 13, noes 0.
Your bill reports, but it is re-referred to finance.
Thank you, Madam Chair, members of the committee.
Thank you, Senator Marsden. Senator Morrissey, it's your time to present.
Good morning, Madam Chair, fellow
Morning.
members.
Good morning.
My bill, Senate Bill 889, eliminates or caps certain fees charged to inmates and local correctional facilities, also known as jails. Virginia jails currently profit from adding regressive taxes to the cost of goods and to services that are provided to prisoners by private contractors. The jails take commissions on phone calls, video calls, email, food, hygiene items, and other goods. An example, Rappahannock Regional Jail took a 95% commission on their phone calls. That's a 1,900% regressive tax. It costs, the cost to do certain things is exorbitant. The Northern Neck Regional Jail charges 53 cents per email. 53 cents per email. One local jail charged $14.30 for a 15-minute telephone call. Even the amount of money that you put on an inmate's account is charged. JPay, you want to put $25. You run up and put $25 on your loved one's account, they charge you $6.95 administration fee. In 2021, jails collected over $43 million in commission revenue from families, and over the last 5 years, $181.5 million in commissions. The Albemarle Charlottesville Regional Jail collected, Senator Serville, $4,200 per incarcerated person a year. The Alexandria City Jail collected over $3,660 per incarcerated person. And as Senator Boysko said, the burden is put on the family that has to not pay for another service. 1 in 3 families with an incarcerated member goes into debt. Now, let me just say this to my good friend John Jones, who I respect immensely. We are not suggesting that you don't deserve money to pay for mattresses or sheets or a Tylenol packet. What we're saying is don't put the onus on the inmate. So for those reasons, I'm asking that this committee support SB 889.
Thank you, Senator Morrissey. I'm going to move to speakers. I think we get the intent of this. You know this bill will have to be re-referred to Finance. Those in the audience in favor of this bill, please come forward. And limit your remarks, please, to less than a minute.
Sure. Thank you. Good morning. We support this bill. It authorizes Bianca Tylik again. I want to just say I think you're going to hear from members who are opposing this bill specifically because of data that might be missing. I want to also reinforce that we did a study on this bill. It was useless time. It was useless time because the sheriffs did not show up. Regional administrators did not show up with any intention to provide transparent data. We believe that, yes, the sheriff should actually, and the regional jail should be funded to run their operations. But we cannot ask a sponsor or patron for a budget amendment without an actual number and without data. We have asked for contracts that have been redacted. They have instructed vendors to not provide their contracts. And these are vendors that have been actually found committing bribery with sheriffs. These are vendors that are offering sheriffs cruises. There is repeated efforts here to hide what data is needed in order to move this bill forward. And so we do implore this committee to move this bill forward and not allow the sheriffs to be the lawmakers and decide that they don't have to do, and I quote, anything in response to a study bill.
Thank you.
Members of the committee, Ben Knotts with Americans for Prosperity. I was on the work group, and I will say that you gave this agency this authority to raise prices and to negotiate these contracts. And it's really important because in part of this, there was a statement that was made that we don't know what we're spending the money on, and the forms are not given an account. And as part of that authority that you've delegated, you're the only one that can make sure the public interest is being preserved and protected. Like she said, cruises are being offered to get a contract. And I'll let Sean address some of the other things in these contracts, but it's a ticking time bomb unless you get hands on these contracts and how they're being negotiated and what's in them. The public is getting angry about it. I mean, that's just a fact.
Next.
Thank you, Madam Chair, members of the committee. Both Mr. Knotts and Ms. Tylik alluded to sort of talked about sort of the lack of transparency, and just this is what we received when we tried to do the study group that I believe that this committee unanimously approved. This is what we got in response. These are the contracts. Now, we were able to actually FOIA some of the contracts and get clean copies, but this is what was provided to the work group, actually by the vendors. However, the vendors weren't asked for the contracts. The sheriffs were asked for the contracts, and the only ones that did provide it were Alexandria. There are some sort of, I'd say, good actors in the space. I actually see one here today. Sheriff Gregory, I know, works really hard, and numbers that we've been able to get, and she's been very open and transparent with us. However, we didn't experience that with everybody else. And one thing I do want to point out that we did discover, even though there was, with the lack of transparency, we did discover that some law enforcement, some of the members of the sheriff's, well, some jails are selling end user data. They enter into data sharing agreements with the phone providers. So if you receive a call from somebody that's incarcerated in one of our jails or one that is in data sharing agreement, your voice print data, your GPS data is being harvested and then sold to data sharing networks. It's not something that's signed up for. Certainly we know that calls need to be recorded for security and surveillance within the facilities. However, where you as an end user, as a free person, are, or your voice print data, that's not part of the deal, not what you signed up for. So we'd like to draw the attention to that. So we support the bill. Thank you.
Thank you. One other speaker in favor, and then please ask if there's speakers in the Zoom room in favor.
Virginia Interfaith Center for Public Policy, and we support the bill.
Thank you. We're now turning to the virtual platform. Those in favor, please indicate so. Keep your remarks to 1 minute.
Sheba Williams, you may provide your testimony.
Yeah, Sheba Williams with no left turns. For brevity, we support the bill and just want to say that this is not on the jails. This is on the families. This is not just on the person incarcerated. So thank you for your time and for the.
Thank you for your brevity.
Charles Meyer, you may provide your testimony.
Morning, Chuck Mayer with Julian Legal. We support this bill. Would like to add some emphasis that a 95% commission is the equivalent to a 1,900% tax on a service. I challenge any member of the committee to find a similar tax rate on any service, and I'd say that if there was one, everybody would be up in arms about it. So I'm not sure why we're okay with it when it's for the families of incarcerated people. And I'd just like to emphasize the serious negative effects that this has on the families of the incarcerated, especially children. When you talk about $4,200 per year coming out of the family member's pocket, I asked the question, what were the impacts of that $4,200? How many medical bills went unpaid? How many doctor's appointments were skipped? How many rent payments were late? How many children didn't get the opportunity to go on a field trip? Why should we be placing an additional burden on families of the incarcerated who are in jails? I would remind the committee that most of the people who are incarcerated in jails are actually held pre-sentencing and pre-trial, so they haven't been convicted of anything. And in the eyes of the law, they're innocent, but we're still punishing their families. So I urge you to take up some regulations and support this bill. Thank you.
Thank you.
Santia Nance, you may provide your testimony.
Hello, Santia Nance, family member of the incarcerated, as well as a work group member and co-founder of Sisters in Prison Reform, and we support this bill.
Okay, I think we've heard a lot of the pro and con. If anybody, certainly the pro, if anybody else is in favor, just indicate yes, you're in favor. If there are any other speakers on the platform in favor.
Willie Brown, you may provide your testimony.
Yes, RHD, Resource Information Help for the Disadvantaged. We are in favor of this bill.
Thank you. Anybody else on the virtual platform in favor?
Francis Belton, you may provide your testimony. Francis Ross, you may provide your testimony.
Francis Ross, Inmate Support Virginia. Myself and 1,400 members support this legislation. Thank you.
Okay.
Juanita Belton, you may provide your testimony.
Juanita Belton, Sisters in Prison Reform, and I support this legislation.
Would you close the platform, and I will come back to those who are in opposition. Anybody in the audience in opposition to this bill? And you're welcome to stand and not speak if you have an eloquent speaker who can cover all of your points. And I believe it's Mr. Jones. Thank you for joining us.
Thank you, Madam Chairman and members of the committee. I'm John Jones, representing the Virginia Sheriff's Association, and we are in opposition to the bill. This bill comes because of the study that was created by Senate Bill 581 last year. And we had one sheriff on the group, and he's here, and a lot of advocates, and we made a good faith effort to do all of these surveys and collect how much we're spending, how much the localities and sheriffs are spending on communications, commissary, work release programs. Then the survey asked, how much do the inmates pay and how much do the local governments pay? And if the inmates' portion is reduced, what will fill the hole, or will the services be reduced? It was a long, extensive survey. We sent it out to all of the sheriffs. Sent a memo and asked all the sheriffs to respond to it. And they only had like 3 weeks and they had to go back 5 years. But we got like 26 or 28 responses out of the 59 jails, which was an excellent response. They're not a part of the report and they were not shared with the other members. So we don't really know how much this is going to cost.
Yes, I do understand. I think your minute has probably expired. Unfortunately, the issue here is whether the jails are actually getting enough money to provide the programs and services, and should that come from another revenue stream rather than the commissary prices.
Madam Chair.
I think they're two different issues, but they converge. Senator Reeves, did you have a question?
Madam Chair, I just made the statement yesterday. I presented a bill, and Senator Hanger was there, that would double the amount of reimbursement from 4 to 8. And this has been a systemic problem since I was chair of this committee, as you've taken over. So we're going to have to do some real work to figure this out. And I think we've got to get people to the table. And I don't think it's fair to leave it on the backs of the inmates, but we up on this dais are responsible for the shortfalls and have to make up that gap. That'd be my statement on the bill.
Madam Chairman, a quick question for Mr. Jones.
I concur. Senator Servell.
Thanks. John, it's hard to believe I've been here 13 years now, but I said it's hard to believe I've been here 13 years now, but I remember, I think it was back in 2010 or 11 when I first was elected, we had that horrific budget environment after the recession that a lot of these statutes that Senator Morsi is trying to repeal went onto the books because of cuts in state revenues to your programs. My recollection is we authorized a lot of these extra charges and supplemental meal programs and all that stuff, and it was all in response to the funding crisis. Is that your recollection, and do you all have any sense of how much money we might need to appropriate to get back to the funding levels that you all were at, so you wouldn't have to do this kind of thing in the future?
Let's just look at telephones or communications, because we didn't see the surveys that came back from the sheriffs. So the sheriffs and the regional jails got together and said, look, this bill's coming up. Let's try to get an idea on what we think is the biggest cost. So we did a survey on communications, which is sophisticated communications that detects escape plots, picks up words, picks up communications relating to safety of the inmates. So it's just not about inmate phone calls, but it's communications. We did a quick response last week, a quick survey, and we got back a response representing 45% of the inmate population in the local jail. So we projected that out, came to $59 million just for telephones. And we're not saying that inmates are paying for that, but that's a local government cost. Then you've got commissary, where when the inmates are assigned to work release, the work release program, when they're assigned to work release, the fee is approved by the court. And when they come in, the deputies actually try to find them a job. And we deliver them. So there's a cost there, but we don't know the total cost. And then you've got the commissary. And the only thing I'd say about the commissary is that's 100% voluntary, optional. They get fed if they don't buy from the commissary. And let me just say, I've got 2 sheriffs here that came to say a brief word about their programs, and Sheriff Barron was the only sheriff on the work group. I'd like for you to hear from those before.
I will take testimony from the 2 sheriffs. We are running out of time. I believe that the rest of you in line probably share the same view as John Jones just explained. The issue is very clear. You need more money to run the jails if, in fact, we're going to reduce the commissary fees. That's not that complicated. We get it. And we want you to run quality jails with rehabilitative programs. That's our goal. And it's also on lawmakers to make sure you have the funding to do that. And I believe that this view is probably widely shared across the aisle. So let me hear from the 2 sheriffs, and then the debate will be with the committee.
So Sheriff Gregory here in Henrico County, I will not stand up here and repeat the things that you've already said and the sentiments that have been spoken. I just say that I too believe that we should have regulation. I have the lowest cost for telephone cost to charges in Virginia, 10 cents. You know, I'm trying to be reasonable and fair, but I also don't want to see the valuable programs that we have go away because we lack funding. I also, in my community, get to witness what impact these programs have on the people that are incarcerated. I do not want to warehouse people. I do not want to have people sit and fester and not address their issues and go back into my community worse or the same way they were when they came in. And that is all I have to say. Thank you.
We appreciate your dedication to that goal, so thank you. One more, Sheriff, or
Yes. I would also mention that the regional jails is represented, was on the work group as well. That's Ted Hull. He deserved a chance to speak because he was on the work group.
okay, all right, Mr. Hall.
My name is Joe Barron, Madam Chair, and I'm Sheriff for the City of Norfolk. I was on the work group. 28 sheriffs responded. You heard that nobody responded, and that's just not true. The work group did not get an opportunity to look at any of the data that was collected. The work group did not do the job that I hoped that it would do so that we could study, as Senator Reeves says, this very big problem as it relates to funding. For me, you know, the funding, not only our inmate programs, but it also contractors provide phone services, for example, create an opportunity for us in services that is public safety related and rehabilitative related. You know, the phone services, just as an example, Madam Chair, please indulge me, because this is an important topic. You know, without using the contractors, we would not have inmate tablets at the Norfolk City Jail, which provides law library, education services, rehabilitative services, plus communication with their loved ones, plus video visitation, all of which would have to be paid for by our city or by the state. It's all unfunded.
Yes, we do understand, and we have to change the financing model of our jails.
Yes,
in
ma'am.
my opinion. So, but thank you. You gave us a very eloquent example. So
Thank you.
I appreciate it. The clerk, please put the 1 minute time. This is the last speaker on
Yes,
this.
sir, Madam Chairman. I appreciate your time and allowing me to speak. I'm Ted Hall, Superintendent of the Northern Neck Regional Jail, and I'm representing the Virginia Association of Regional Jails. And I did participate in the work group. Our opposition, and we do oppose this bill. The opposition that we have is not related to policy. We are public officials. We don't make policy. We execute policy. The problem is the work has not been done to understand, A, how much it's going to cost, who's going to pay for it. This issue is existential. We're not talking about nickels and dimes. It's 20% of my budget. And I would ask that we consider. No one is opposing what we're trying to do is get to the point where how much it's going to cost and who's going to pay. I would also reflect, and again, I know I have a minute. Several things were said. I was referenced. My jail was referenced in the previous presentation. I could spend hours talking about this issue. I can address any one of the things that have been said about this issue at length. I will say that some of the things that have been said here are factually incorrect. There's no jail selling documents. There's no jail selling information. Unbeknownst, a jail is required to follow law, and that includes contractual law. There's something called proprietary information, and when a vendor says proprietary, then I have an obligation to understand their position when they redact the information. And I know this for certain. Rappahannock Regional Jail is not charging 95% commission. The Prison Policy Initiative in 2008 referenced how much each jail in Virginia was charging. I referenced it in my contribution to the work group, and it was ignored. The point I'm saying, Madam, I appreciate your time. I appreciate your indulgence. I just want to say we appreciate what you're trying to do. Our opposition is based on how much money, who's going to pay, and where the money is going to come from. Thank you, Madam.
Thank you. I think that paradigm has been very eloquently stated and presented. We may be ready for a motion.
Can I wrap up?
Madam Chair, can I just ask one question?
Senator Boysko.
Senator Morrissey, could you confirm to us that you've got a budget amendment in that would take on some of this cost?
There's not a budget amendment in because we didn't have the data. I think Senator Hanger wants to say something.
Who is senior member of our Finance Committee.
Thank you, Madam Chair. Just to speak to the issue briefly, Senator Servo was correct with the 2011 date. At that time, the per diem for locals was $8. We rolled it back to $4. Senator Reeves has a budget amendment in which would help with this. It'll have to be decided in finance, which would cost about $15 million if we put it back to $8 again. There's a nexus also to Senator Peake's bill on state responsibles, which we adjusted somewhat last year. So it's bigger than this bill. And I think the point from the sheriffs is the state has a responsibility to help pay for this. And if we take a funding source away from them, we're going to have to ante up the money.
I think the expectation is that this will go to finance, but if it were to come out of finance, finance would have to find another funding stream. I don't think our lawmakers on the money committees would leave our jails.
Madam Chair, I would think that what we'll look for is a reasonable spot in terms of negotiating a per diem rate based on the sheriffs then being able to ensure, a reasonable rate across the board.
I think
that's consistent, something of that sort.
And maybe a reasonable increase in the commissary profit. So
Madam Chair, let me make this final point. Our current governor many of his doings are data-driven, which is it's a good metrics to use. And let's give credit where credit is due. The cost for the first minute in Chesterfield is 11 cents a minute, first minute. Farmville, 9 cents. Henrico, 13 cents. And Richmond, 7 cents. And if you look at the services that the Republican sheriff in Chesterfield County provides to those inmates, it's outstanding, as is in Henrico County. But then you have folk like Culpeper that at $4.64 a minute. So for de minimis amounts of money, 11 cents, 7 cents, 13 cents respectively, we are providing outstanding services. But some are not doing that, and they are charging exorbitant rates. And the last thing I'm going to say, Madam Chair, is you directed us last year to have a work study. We had 5 meetings, well-attended, 15 to 20 people per meeting over the summer. You directed us to deliver a report. We delivered that report, a 127-page report, and we did it on time.
Yes, you did.
And we also noted the dissents in there. Yes. But there were a diverse group of people, including the Republican co-chair, Delegate Batten, that supported this bill.
I understand.
So we fulfilled our obligations and our duties, and I think we did it in a timely fashion, and I hope that the body got this report.
I am delighted you fulfilled your obligation. Colleagues, this issue is before us.
Madam, I'd like to move that we report and refer to finance.
That's your motion to refer. Second? I second that motion. Okay, will the clerk open the roll, please? Senator Morrissey, do you want to vote?
Yes, I'm sorry.
I can mark it.
Thank you.
Ayes 7, no 7.
Senator Morrissey, you need to vote.
8, no 7.
You didn't. You need to vote.
You said that you're going to put me
I
up.
will mark. Ayes 8, no 7.
Okay, your bill passes and it's re-referred to finance, so there'll be more discussions about where that
Yes, ma'am.
proper balance is. Colleagues, I'm going to move my bills. I'm the only presenter left, and mine will be moved to next week. We did good work. Is there any other business to come before the committee, David? Okay, the committee shall rise.
Good day.